Picture this: you're minding your own business, sipping your morning coffee, enjoying the sunshine streaming through your kitchen window, when suddenly your peaceful day is shattered by the arrival of a legal notice. Now, before you start picturing yourself in a courtroom drama, let me clarify. This isn't your usual legal drama. This is about your front lawn, your grass. It's too brown. The Homeowners Association wants to know why. And that's when your perfect day turns into a homeowner's nightmare. You tend to your garden, fix the sprinklers, add some fertilizer, and wait for the compliments to roll in. But instead of praise, you get a violation notice. It's not because your grass is brown or dead, but because it's not green enough. So you ask questions, seek solutions, and try to fix the problem. But the HOA, instead of being appreciative, takes you to court. They claim you were negligent, accusing you of intentionally letting your grass turn brown. What's worse, they want to make you pay for the upkeep of the entire shared irrigation line, even though you only had a problem with your part of it. Now here's the kicker. It's not a story from a legal drama or even a fictional HOA horror story. It's real life. And it happened to someone who decided to take their story online. After getting a second violation notice in a year, John Doe decided to fight back. He contacted a local news station, bringing the HOA's actions to public attention. The story quickly gained traction, turning the tables on the HOA. The Homeowners Association found itself under the hot sun of public scrutiny. Facing backlash and negative publicity, the HOA was forced to change its stance. Does this mean that the HOA backed down? Absolutely not. But they did send a letter retracting their accusation of negligence and dropped the lawsuit. It also got them to drop the mandatory mediation requirement. And here's another interesting twist to this tale. John Doe's HOA, like many others, uses a tool called Nextdoor. You know, that neighborhood app where people share everything from lost pets to local news. But recently, it's become a battleground of sorts. Some HOAs have been using it to post violation notices publicly shaming homeowners. Can you imagine the embarrassment of having your private violation notice plastered for the entire neighborhood to see? But it's not just about the humiliation. It's about the power the HOA wields in situations like these. Take, for example, a case where a family in California had their Nextdoor post turned into a neighborhood court. Their crime, having an unmowed lawn. In another instance, a disabled veteran in Texas was publicly called out for his messy lawn. These aren't just cases of strict neighborhood watch. They're examples of how far some HOAs will go to assert dominance in a community. John Doe's story is a testament to the fact that standing up to an HOA can work. By taking his story to the public, he turned the tables on an organization that had all the power and used it to intimidate and shame. His story is a reminder that we shouldn't let organizations, no matter how powerful, abuse their authority in our communities. HOAs are supposed to be there to maintain the aesthetic appeal and property values of a neighborhood, not to become a nuisance or a bully. While they have the right to set guidelines and enforce rules, they don't have the right to use those powers to humiliate, harass, or intimidate residents. The power dynamic between an HOA and its members is inherently imbalanced. The HOA has the upper hand, often wielding significant fines and legal action as weapons at their disposal. So what can you do if you find yourself in a similar situation? The answer: knowledge is power. Understanding your rights and the limitations of HOA authority is the first step towards protecting yourself against potential abuses. Don't let yourself be bullied into submission. Knowledge is your shield against the potential tyranny of an HOA gone rogue. Just like John Doe, you can stand up for your rights and maybe even those of your neighbors. Who knows, you might just inspire others to do the same. In our hyper-competitive housing market, many homeowners have taken up residence in suburbs where homeowners associations or HOAs rule the roost. These associations typically oversee the aesthetics of houses in a neighborhood. They can enforce rules regarding paint, colors, landscaping heights, vehicles parked on driveways, trash bins, and an array of other things. According to data collected by the Community Associations Institute, there are around 30 million properties in the US that fall under the authority of HOAs, making up 21% of all housing units. However, what happens when an HOA takes its authority too far? That's exactly what happened to Lena, the protagonist of today's story. It all started with a patch of dry grass. For homeowners like Lena, life in an HOA can be both convenient and annoying. You get to live in a community where the streets are clean, houses are mostly well maintained, and the neighbors aren't blaring music or holding massive parties every weekend. At the same time, you have to put up with busybodies, trivial disputes, and the occasionally tyrannical HOA board. Even so, Lena liked living in her suburban development. She'd lived there for more than 10 years and never had a reason to complain. Sure, she sometimes disagreed with the board, who doesn't? But for the most part, she trusted that they had the best interests of the community in mind. Then one day she got a violation notice in the mail. It stated that her front lawn was no longer in compliance with HOA standards because of a patch of dry grass the size of a throw rug. Now, Lena had noticed the spot herself, but she wasn't too worried about it. It was summertime. There'd been a heat wave and her young daughter had trampled it while playing hopscotch. Also, she knew there was an issue with her irrigation system, so she figured she'd fix it as soon as a repairman could come take a look. The very next day, Lena's phone rang. She looked down to see an unknown number from her city. Figuring it was probably a telemarketer, she almost let it go to voicemail, but something made her pick up. It was her local water company. The woman explained that they denoticed an abnormally high amount of water usage coming from Lena's house and wanted to check for leaks. Startled, Lena told her about the dead patch of grass and the upcoming repair appointment. The water company suggested she take pictures so she could keep track of the issue and send the pictures to her insurance company. She thanked the woman and hung up, slightly uneasy but otherwise unfazed. But then later that week, the letters started pouring in. First came the official violation notice from the HOA, which Lena expected. But then she got another notice from the HOA president. He said he'd been tipped off by the water company about the brown patch of grass and demanded to know why she had unfixed it yet. Confused, Lena replied that she'd already contacted a repair specialist and was awaiting his arrival. A few days later, the repairman came and confirmed that the pipes leading to the front strip were broken. Lena paid him out of pocket and sent copies of the bill to the HOA president with photos of the broken pipes and the repaired lawn. Her theory was that the HOA might want to pitch in since the pipes ran through the common area. Plus, it was clear from her correspondence with the president that he was eager for the repair to be done. But the HOA took a strange turn. Rather than thanking Lena for fixing the problem, the board sent her a letter saying that she'd violated several bylaws, including those regarding communication and dispute resolution. They wrote that they planned to escalate the matter to mediation, even though they'd never given her a chance to speak at a formal hearing, nor had they notified her of any deadlines she'd missed. The letter also mentioned that her failure to notify the board of the broken pipes constituted a violation, even though the board president had already asked her about the issue and even though she'd sent him photos. By this point, Lena was stunned. She hadn't meant to violate any rules and she'd clearly communicated with the board about the issue. So why were they treating her like a hostile party? When she reached out to the board president for an explanation, he stopped answering his phone. Lena was dumbfounded. She thought her HOA was there to protect her property value and quality of life, not threaten her with legal action over a brown patch of grass. All she wanted was a little understanding, but instead she got nothing but silence. Still confused about the HOA's reasoning, Lena decided to contact an HOA expert to ask some questions. She said, "The entire situation has been completely baffling and frankly quite shocking. I'm pretty sure that they don't want to listen to my side of the story. I've never had an HOA be so antagonistic, when I've always paid my dues on time and kept a beautiful home. I'm angry and upset because I'm convinced they just want to bully me into submission. I still don't understand why a simple oversight became such a huge issue, or why after I fixed the problem and showed proof that I did, they continued to threaten me. It makes no sense." To make matters worse, Lena discovered that the irrigation system partially served the HOA's common area, which her neighbor confirmed had been the case long before she bought her house 5 years prior. Then one astute commenter on Reddit made a chilling observation. If your irrigation is tied to the common area, and you repaying for water that also benefits HOA land, they may be rushing to mediation, before you realize you've been overpaying for years. That's when Lena realized, this wasn't just about a brown patch of grass. This was about money, power, and the weaponization of bylaws by HOA boards that no longer saw homeowners as neighbors, but as opponents. So what happens next? Now that Lena knows she might have been overpaying for water and landscaping maintenance, she decides to fight back against her HOA, in order to explore the tactics these organizations use to intimidate residents and bend them to their will. We spoke with attorney Jason Abera of Florida-based HOA Legal Group. He said, "In many cases, HOAs seek to bully homeowners into doing what they want them to do. There are situations where HOAs want to squeeze homeowners for additional money. In those cases, an HOA might find a technical violation, often something small, and then make a big deal out of it. Sometimes they try to convince a homeowner that it's better to pay up rather than fight it. Other times, the HOA wants to use the violation to scare the homeowner into doing what they want. For example, an HOA might threaten to place a lien on a home unless the homeowner fixes the violation. In some cases, an HOA uses the threat of legal action, court and liens to scare the homeowner into giving in. Arbear also pointed out that mediation is often used as a bullying tactic. Sometimes an HOA thinks that they can use mediation to trick a homeowner. Mediation isn't necessarily a bad thing, but in some cases, an HOA might suggest or demand mediation early in a dispute, especially if there's a financial incentive for the HOA to resolve the issue quickly. During mediation, a neutral third party helps facilitate a settlement between the HOA and the homeowner. The mediator doesn't make a decision for either side. Instead, the mediator tries to help the parties reach a mutually acceptable solution. An HOA might demand mediation because they want to prevent the homeowner from taking the dispute to court. Courts are expensive and time-consuming, so if the HOA knows that they're likely going to win in court, they may want to avoid it. Some courts even require parties to attempt mediation before going to court. Another reason an HOA may demand mediation is that they want to stop the homeowner from talking to others about their dispute. This is known as a gag order, and it can be an effective way for an HOA to control the narrative about a dispute. Finally, an HOA may demand mediation simply because they want to appear reasonable. Demanding mediation shows that the HOA is willing to compromise and settle the dispute without going to court. This can be an effective way to pressure a homeowner into agreeing to a settlement. So what should homeowners like Lena do if they find themselves in a similar situation? Arbear recommends starting by reading the governing documents, especially the conflict resolution section. Find out what options you have for resolving a dispute with your HOA. Review the complaint process outlined in the documents and follow it closely. Make sure you comply with all deadlines and submit all required documentation. Keep copies of all communications with your HOA, including emails, letters, and text messages. Don't be afraid to speak up if you feel like your rights are being violated. If you're not comfortable speaking up in person, consider sending your HOA a written statement explaining your concerns. If the dispute can't be resolved informally, you may need to take more formal action. This could involve filing a lawsuit or taking your complaint to a government agency. Before taking any action, consult with an experienced HOA attorney to discuss your options and protect your rights. And now, a quick word from today's video sponsor. Now, back to the story. In the end, Lena decided to fight back against her HOA. She couldn't believe that they'd turned something so small into such a huge issue, so she hired a lawyer and prepared for a long battle. As it turns out, Lena had a strong case. Her lawyer was able to prove that the HOA had violated their own bylaws by skipping steps in the conflict resolution process. Plus, the lawyer found evidence that the HOA had mismanaged funds related to the common area maintenance. With that kind of evidence on her side, Lena was able to negotiate a settlement with the HOA. She didn't have to pay the fines, and the HOA agreed to reimburse her for her legal fees. Lena was relieved to have won her case, but she felt bad for the other homeowners in her development. Many of them were elderly and had been bullied by the HOA into paying hefty fines and making costly repairs. She hoped that her victory would give them the courage to stand up to the HOA and protect their own rights. It began like so many HOA stories do, quietly. One morning, Lena stepped out onto her front porch and found a plain envelope tucked into her mailbox. No bold lettering, no urgent stamp, just the familiar HOA return address and her name typed cleanly in the corner. She thought little of it, maybe a newsletter or a reminder about dues. Inside was a letter titled, Notice of Violation, Landscape Maintenance, Non-Compliance. The wording was polite at first, almost clinical. Our routine inspection of the community has noted that the condition of your front yard landscaping is not currently meeting community standards as outlined in Section 4.3 of the HOA Covenant Guidelines. The letter went on to specify that Lena's grass showed visible browning and dryness, which, it claimed, was negatively impacting the overall uniformity and visual integrity of the neighborhood. It requested that she restore her landscaping to acceptable condition within 10 days. It was signed simply, Board of Directors. Lena blinked at the letter, confused. Yes, her lawn looked dry, but they were deep into August, and her region had been suffering through an unseasonal dry spell. She'd actually been watering regularly and assumed the browning was temporary. Still, she wasn't unreasonable. If the HOA had a concern, she'd address it. What she didn't know at that moment was that this notice, barely 2 paragraphs, would become the first domino in a cascade of legal threats, financial losses, and bureaucratic gridlock that would leave her questioning whether she even wanted to stay in her home. A closer look at the lawn. Lena was a responsible homeowner by any definition. She'd lived in her house for 11 years, paid every HOA due, kept her home well maintained, and had never once received a violation before. The day after receiving the letter, she took a closer look at the lawn. True enough, several patches were bone dry. She pulled up the sprinkler heads and noticed something strange. There was no water coming through. She manually activated the irrigation system via the control box in the garage, still nothing. She walked over to her neighbor's yard, which shared a fence line with hers. Their grass looked pristine, freshly watered. Confused, Lena reached out to the original landscaping contractor who had serviced the property years ago. After a quick inspection, he confirmed what she suspected. A critical valve in the irrigation system had failed, rendering her sprinklers inactive. But here's where things started to get complicated. The repair, and the HOA's shared history. The irrigation system on Lena's property was not fully independent. Years ago, before she moved in, the HOA had paid for a shared irrigation layout that connected her front yard zone to a segment of the common area landscaping, including a shared water supply and electrical routing. This meant that while Lena was responsible for maintaining her lawn, she didn't have full control over the system. In fact, when the contractor went to shut off the master valve to repair the damage, he realized the shutoff was located on HOA land, behind a locked maintenance gate. He needed board approval to access it. Lena immediately emailed the HOA president, explaining the situation in detail. She'd received the violation letter. She discovered the malfunction. She had a licensed contractor ready to do the repairs, but the HOA needed to unlock the valves so the fix could happen. She included photos, repair estimates, and a request to schedule the access window. No reply. She emailed again the next day, still nothing. The contractor, sympathetic but bound by liability, informed Lena he couldn't proceed until they received written HOA approval to access the shared valve. Countdown begins. Lena was now 5 days into her 10-day compliance window. She had taken every step a reasonable person would. She had identified the issue, found a licensed vendor, requested the HOA's cooperation, but the board was silent. On day 7, she received a second letter. This one wasn't polite. This is your second and final warning before non-compliance is escalated to formal mediation. You are advised to correct your violation immediately. No mention of her previous email. No acknowledgement that the system was shared. No understanding that the very repair they were demanding could not be completed without their help. At this point, Lena began to feel the ground shift. She called the property management company listed on the HOA website. The receptionist took a message but said the board only met once a month and didn't take direct homeowner complaints. She asked to speak with the HOA attorney. She was told they couldn't release that information. Legal threats begin on day 9, with the repair still stalled. Lena finally received a short email. The HOA board cannot grant special access to irrigation controls without a formal work request filed and board vote. In the meantime, please comply with landscaping standards. It made no sense. She had already submitted all the documentation. There was no special request, just a time-sensitive fix. The next day, day 10, a formal attorney letter arrived via certified mail. Re-notice of mediation, property maintenance violation. The letter stated that Lena was being referred to mandatory mediation for violation of her landscaping covenant. She would need to attend a mediation session with an HOA selected attorney and, if she failed to comply, could face fines, liens, or legal fees, from neighbor to adversary. What had started as a minor maintenance issue was now a legal escalation. Lena was stunned. She had done everything correctly. She acknowledged the violation, she scheduled the fix, she communicated clearly, but the HOA had gone silent, ignored her requests, and then escalated the situation before even allowing her to resolve the problem. What she didn't realize yet was that the entire irrigation setup, including power, pipes, and utility costs, was part of a shared infrastructure she had unknowingly subsidized for years. She wasn't just being fined unfairly, she was potentially being scapegoated for a maintenance failure she didn't fully control, and now she was facing lawyers. This case is a textbook example of how procedural failure combined with poor communication can escalate a minor issue like a broken sprinkler head into a legal confrontation. From a professional HOA management standpoint, the board made a critical misstep early on. Failure to acknowledge and respond to the homeowner's documented repair plan. When a homeowner responds to a violation in good faith, especially with licensed contractors involved and communication records submitted, a responsible board's obligation is to collaborate, not escalate. Also concerning is the shared irrigation system. When common infrastructure blurs the line of responsibility, the HOA holds partial liability for timely repairs, especially if their access controls are blocking the homeowner's ability to comply. If the board required a formal vote or procedural request, it was their duty to inform the homeowner immediately, not ignore her for 7 days. Jumping straight to mediation after minimal engagement is a red flag. Normally a violation should follow a clear 3-step process: warning, grace period, fine and/or hearing, not legal mediation. That escalation path exists to avoid exactly what happened here, a breakdown of trust and misapplication of power. Lastly, the HOA's refusal to release the attorney's contact or provide alternatives may reflect an insular, protectionist culture, something that often correlates with overreach and lack of transparency. Now let's shift perspectives. If this were my client, here's how I'd handle it. First, I'd remind Lena that most HOAs have a 24 to 48-hour response requirement. If the board didn't acknowledge receipt of her letter, she could follow up with a phone call or email, reiterate the offer and request a meeting. The goal would be to get the board's definitive position, whether they want to mediate, collaborate, or reject her offer. This sets the stage for the next step. If the board rejects her offer, I'd advise Lena to send a brief email outlining her position and the offer she's extended. This serves 2 crucial functions. It documents her willingness to resolve the issue and provides context for the next step, the violation process. In this case, the board has 2 options: mediate or enforce. If they choose to enforce, they must do so properly, which typically involves a warning, a grace period, and then a fine and/or hearing. The violation process exists to protect both the association and the homeowners. It ensures that everyone is treated fairly and consistently. Now let's analyze the potential outcomes. If the board accepts her offer, the case is closed, the violation disappears, and we move on. If the board rejects her offer without going to mediation, I'd advise Lena to send a demand letter outlining the damages and the cost to repair the irrigation. This sets the stage for a possible lawsuit and gives Lena the upper hand, because she has documentation of her offer to repair at her expense. If the board rejects her offer and refuses to mediate, I'd advise Lena to send a demand letter with a copy of her offer to repair. This sets the stage for a possible lawsuit and gives Lena the upper hand, because she has documentation of her offer to repair at her expense. In conclusion, had the board accepted her offer, the case would have been closed. No violation, no attorney, no drama, but instead, through a combination of inaction and escalation, they transformed a simple repair into a contentious legal issue involving multiple parties. Remember, effective communication and collaboration are key to resolving issues like these. Ignoring problems or failing to respond only escalates them. Lena's inbox pinged late Tuesday afternoon. The subject line, notice of mandatory mediation. She blinked twice. Had she missed a step, a deadline, something? Yet now, the HOA was skipping ahead, past warnings and fines, to mediation. She opened the PDF attachment and read the letter slowly. The association has determined the issue remains unresolved. Mediation will take place within 14 business days. You may bring legal representation. Legal representation. Lena wasn't sure whether to laugh or panic. Her mind flashed to her last attempt to speak with the board 6 days ago. The board president had not replied, nor had the property manager. Not one return call. She clicked through her emails sent folder, reading the trail. Sent: hi, I discovered the irrigation failure. Sent: attached is the repair invoice. Sent: the system is operational again. Please confirm. No responses. 0. It was like screaming into a canyon. The community's online portal offered no guidance. When she checked the complaint status, it simply read, escalated to legal department. On Reddit's HOA forum, Lena explained her situation anonymously, unsure if she was overreacting. I'm just stunned, she wrote. I fixed it. I paid for it. Why am I being treated like I'm ignoring the issue? One commenter chimed in almost instantly. They may be trying to create legal pressure, so you fold and just accept a fine, even if unjustified. Another said, request the HOA's complaint procedures in writing. They're required to provide that before escalating to mediation. Sounds like they skipped several steps. Lena hadn't thought of that. The governing documents. She dug through her welcome packet from 2 years ago, the thick stack of bylaws she had never read. Sure enough, there it was on page 38. The HOA board must provide a written notice of violation, followed by a 30-day resolution period. Mediation as a last resort. Her heart sank. There had never been a 30-day window. Just a single notice about the lawn being substandard, and this sudden legal escalation. She had paid and acted in good faith, and now she was being treated like a defiant resident, trying to game the system. The mediation date arrived faster than she expected. Lena couldn't afford an attorney, but she showed up at the local courthouse anyway. The HOA's lawyer greeted her briefly but refused to answer questions about the complaint. I was hoping we could talk through what the actual violation is, Lena asked. It's all in the complaint file, the lawyer replied curtly. I wasn't given that. You should have requested it sooner, he said, adjusting his tie. Inside the mediation room, the board president sat silent, while the HOA's lawyer took the lead. They claimed Lena had failed to maintain her lawn for a period exceeding 21 days, that she failed to communicate her repair plans in a timely manner, and that she demonstrated an unwillingness to comply. Lena could hardly believe what she was hearing. I submitted receipts and wrote twice. I called too. You didn't reply, she snapped. The mediator nodded slowly, clearly used to HOA disputes, but seemingly surprised by the missing communication on the board's end. The session ended without resolution. The HOA demanded that Lena sign a compliance agreement and pay a $500 fine for administrative non-responsiveness. She refused. Outside the courthouse, her hands were shaking. The HOA wasn't acting like a non-profit board protecting neighborhood standards. They were treating her like a threat, someone to be punished. That night, Lena went back to Reddit and updated her post. This time, it blew up. I was railroaded into mediation by a silent board and now face a fine I deserve. Hundreds of responses flooded in. You need a lawyer immediately. Demand to see board meeting minutes. Maybe they never voted to pursue this. If the irrigation system is tied to common property, that fine may not be enforceable. One user even suggested filing a complaint with the state's Department of Real Estate, which oversees HOA conduct in her state. That sparked something in Lena. For weeks she had been reactive, scrambling to fix, respond, clarify, and now defend. She was done playing defense. She took out a yellow legal pad and started writing everything she remembered. Everything she had done, saved every email, and labeled every photo. And then, at the top of the page, she wrote a question that would define everything that came next. What if I'm not the only one? By morning, she was on the phone with a local consumer protection attorney who offered a free 30-minute consultation. She scanned and emailed her entire file: repair invoices, violation notices, HOA correspondence, and the mediation summary. Within 2 hours, the lawyer called back. Lena, he said, based on this, it looks like the HOA may have committed a procedural violation of its own bylaws. That fine won't hold up in court. Her stomach dropped again, this time from relief. But the lawyer wasn't done. I've dealt with this HOA before, he added. You'd be surprised how often they bluff residents into paying illegal fines. This segment highlights a disturbing but increasingly common trend. HOAs using mediation as a weapon rather than a resolution tool, and in this case, the board bypassed their own governing documents, a critical misstep that could undermine their legal standing. Let's start with the process failure. According to most HOA charters and community bylaws, mediation is a final step, not a first or second one. A homeowner must receive a written violation notice, a 30-day cure period, and a fair opportunity to be heard, often in the form of a board meeting or hearing. Lena received none of these in proper form. Jumping to mediation without honoring due process isn't just unethical, it could be legally actionable. Then we have the issue of documentation suppression. Lena wasn't given access to the full complaint, wasn't provided with minutes from board meetings, and couldn't verify whether the board had even voted to escalate her case. This lack of transparency is a red flag, and it violates open governance standards for most HOA boards, especially when DOA boards are involved. Now let's talk about power imbalance. The HOA's lawyer showing up to mediation without disclosure, while Lena was unrepresented and uninformed, reeks of legal intimidation tactics. Most homeowners are anti-equipped to fight back in these settings, which is exactly what some HOA boards count on. The final takeaway: if you're ever summoned to mediation by your HOA without warning, stop, get a copy of your bylaws, demand full records. And if something feels off, it probably is. Lena was right to start fighting back. And unfortunately, this is just the beginning. Lena had assumed that paying for the irrigation system repair, notifying the board president, and documenting the process would be enough. She couldn't have been more wrong. Just 5 days after receiving the mediation summons, a certified letter arrived at her door. Inside was a formal legal notice from the HOA's attorney. The letter accused her of willfully violating community standards, neglecting her landscaping responsibilities, and creating community disharmony. Lena read it twice, stunned. She had not ignored the problem, she had fixed it, and she had receipts, contractor reports, even photos of the lawn before and after the repair. Why wasn't any of that being acknowledged? She contacted the board president again, no reply. She then wrote to the full board, submitting a formal dispute letter outlining her version of events, attaching supporting documents. Still nothing, no response, no confirmation, just silence. Meanwhile, another letter arrived. This one was more aggressive, citing potential fines, legal costs, and possible liens if Lena did not cease and desist her non-compliant landscaping practices. I didn't even know what that meant, Lena later said. How do you cease and desist something you already fixed? Her lawn, while not perfect, now met the exact HOA landscaping standards published in the community handbook, but the HOA wasn't backing down. Instead, it felt like they were trying to bury her under legal pressure, hoping she'd fold. Worse still, Lena learned that no other homeowner had ever received legal letters for minor irrigation issues. She wasn't being treated like a neighbor with a fixable problem, she was being treated like a hostile defendant in a legal war. The situation escalated rapidly, and Lena, once a quiet homeowner who volunteered at the community garden, was now seen by the board as a threat. Her calls to the HOA's management company were now being ignored entirely. That's when she started keeping meticulous records, every email, every timestamp, every unanswered call, because something told her this wasn't just about grass. This was about power, and the board had just declared war. Lena's situation reflects a disturbing pattern we've seen in numerous HOA disputes: the premature escalation to legal threats, often before proper communication or due process has taken place. Let's break down why this matters and how it's potentially abusive. 1. The absence of standard violation. Procedures: most HOAs are required to follow a 3-step disciplinary process: notice of violation, opportunity to cure, typically 30 days. Hearing before the board. In Lena's case, we see a direct jump to mediation and legal threats, skipping the due process entirely. This can be a major violation of state HOA statutes and the association's own bylaws. 2. Weaponizing attorneys to create pressure. The arrival of attorney letters is not only psychologically intimidating, it creates financial fear. Even if Lena is in the right, the looming cost of legal representation and drawn-out disputes may lead a homeowner to back down. This tactic isn't about resolution, it's about submission. 3. Ignoring documentation and evidence. Lena did everything correctly. She repaired the system, alerted the HOA, and provided proof. When boards refuse to acknowledge or respond to that documentation, it strongly suggests that the conflict is no longer about the original violation, but about something deeper, possibly personal retaliation or power assertion. 4. Selective enforcement. No other homeowners were subjected to legal letters for similar issues. That's selective enforcement, and it's illegal in many jurisdictions. An HOA must apply rules uniformly. Otherwise, they open themselves up to litigation under fair housing or discrimination laws, depending on the context. 5. Advice for homeowners facing similar attacks. Start a paper trail. Document everything: emails, calls, letters. Time-stamped proof can save you. Request a hearing in writing. Force the HOA to engage in due process. Review your CC and RS and state statutes. Know your rights better than the board does. Contact an HOA attorney or ombudsman. Many states now have legal advocates for homeowners unfairly targeted by HOAs. Go public if necessary. Sometimes media pressure or online exposure changes behavior faster than courtrooms do. Bottom line, this isn't just about broken sprinklers or dry grass. It's about a board possibly overstepping its authority, bypassing protocol, and leveraging legal tools to silence or punish a compliant homeowner. These are the very warning signs that HOA abuse watchdogs flag as red flags for systemic dysfunction. After receiving the attorney's letter, Lena did what any rational, responsible homeowner would do. She sought dialogue. She emailed the board. No response. She followed up with certified mail, requesting a hearing. Silence. Every attempt she made to engage the HOA in a rational discussion was met with a wall of silence or worse, more threats. Then came the bombshell. The HOA informed Lena that the matter had been referred to mediation. No prior discussion. No opportunity to resolve the issue amicably. Just a notice. Mediation was now scheduled and attendance was mandatory. I asked them, "Why are we in mediation? I've already fixed the issue." I provided proof. Their response was a single line. "Your attendance is required per Section 6 of the enforcement policy." That was it. This sudden shift left Lena feeling ambushed. She wasn't opposed to resolving the matter. In fact, she'd done everything to do just that. But this process felt engineered, not to resolve but to control, punish, or extract. Lena researched Section 6 of the HOAS policy. It mentioned mediation, yes, but only after due process, written notice, a board hearing, and a chance to appeal, none of which had occurred. And yet, here she was, being summoned to mediation like a corporate dispute, while the actual source of the conflict, the shared irrigation system, remained untouched and unacknowledged. The shared irrigation twist. During this phase, a neighbor casually revealed a detail that recontextualized the entire dispute. The irrigation system Lena had been penalized for was actually part of a shared utility line running through multiple homes and owned by the HOA itself. This meant the HOA was responsible for system maintenance, not just oversight. The costs Lena incurred repairing it should have been reimbursed, not punished. It felt like they were hiding something, Lena later wrote. Almost like punishing me was easier than admitting they were responsible. She brought this up in a final email to the board, with invoices, receipts, and photographs attached. No response. Mediation day. Lena showed up, folder in hand.com, and collected, across the table, the HOA's attorney and a representative she'd never met before. The atmosphere was cold, professional, distant. The mediator, a retired judge, asked both sides to present. Lena did. Factually, clearly, with all documentation in place. The HOAS side, nothing specific, just vague references to landscaping standards, and failure to comply. The mediator paused. He looked at the documents, then he looked at Lena, then he asked the HOA rep a pointed question. "Why wasn't this resolved when she first notified you of the repair?" The response: "We were following policy, but it was clear the process had gone off the rails long before that room." No resolution. Yet the mediation ended inconclusively. No agreement, no admission. But Lena left with something more valuable: the mediator's notes, and a recommendation for a formal review of the HOA's procedures. She wasn't done fighting. This was no longer just about her lawn or her water bill. It was about every homeowner who'd been dragged into a conflict they didn't start. And for Lena, the next chapter would be about holding this board accountable not just for her, but for the entire neighborhood. Lena's experience offers a textbook example of how process manipulation is used to intimidate and suppress homeowners who ask too many questions or assert their rights. Let's break down what went wrong and what this reveals about deeper dysfunction in many HOAs. 1. Mediation as a control mechanism. Mediation is meant to be a tool for resolution, not retaliation. In HOA disputes, voluntary mediation is often encouraged after due process, but in Lena's case, the board skipped essential steps. No formal hearing, no attempt at internal resolution, no written acknowledgement of the homeowner's fix. By moving straight to mediation, the board forced the homeowner into a defensive posture, while giving the illusion of fairness. This is a classic strategy: appear lawful while acting unlawfully. 2. Stonewalling as an institutional strategy. Lena faced total silence, emails, letters, and even certified mail ignored. This isn't just negligence. It's a calculated form of obstruction designed to frustrate the homeowner, weaken their case by creating gaps in documentation, shift the power dynamic entirely in the board's favor. Many HOA boards adopt this tactic, knowing most homeowners will give up before they reach formal dispute channels. 3. The irrigation system revelation. Once it became clear that the irrigation system was part of the shared infrastructure, not Lena's private system, the board's motives became more suspect. If Lena had proof that the HOA owned the system, that she paid out of pocket for repairs, and that she informed them immediately, then the board wasn't just mistaken, they were potentially in breach of fiduciary duty. They ignored their own responsibilities, punished a homeowner for their failure, and then refused to acknowledge the mistake. This is grounds for a civil claim in many jurisdictions. For what should have happened instead, a responsible HOA board would have logged the violation, investigated the irrigation issue, recognized their own liability, worked collaboratively with Lena to repair and refund costs. Instead, they chose to escalate, perhaps to avoid embarrassment, exposure, or reimbursement, or worse, because they believed no one would stop them. 5. What you can learn as a homeowner if your HOA uses mediation or legal threats without due process. Document every contact attempt. Show your intent to resolve. Force transparency. Request records of votes, repair decisions, or maintenance logs related to your issue. Bring a witness to mediation, even if informal. Having another party observe the process can deter abusive behavior. Push for mediator neutrality. Research the mediator's background. Some HOAs work with repeat-friendly mediators who lean their way. Red flags in this case. Unilateral escalation without documented violation process. No accountability for shared infrastructure responsibility. Attorney intimidation used prematurely. Board silence used as a defense strategy. Failure to acknowledge provided evidence. Bottom line, what looks like miscommunication is often a shield for misconduct. Lena's board acted not out of ignorance, but out of calculated indifference. When boards believe they're untouchable, they stop acting in the community's interest and start acting in their own. Lena returned from mediation frustrated, but far from defeated. If anything, the experience only fueled her determination to get to the bottom of what she increasingly believed was a targeted campaign of retaliation, not a procedural misunderstanding. She took the mediator's advice and began digging. The records request. Using her rights under state HOA statutes, Lena submitted a formal records request to the board. She asked for all violation notices related to her property, HOA meeting minutes from the past 12 months, invoices and repair records regarding the shared irrigation system, all correspondence involving her case. Under most state laws, HOAs are required to respond to such requests within a certain number of days, typically 10 to 30. She received one PDF, poorly scanned, missing key pages, and conspicuously redacted. The board claimed the rest was confidential board deliberation, but what was included told her plenty. A telling line in the minutes buried in a single line from a February meeting. Board agrees to pursue enforcement action regarding redacted in accordance with attorney guidance, bypassing standard hearing process due to prior non-responsiveness. There it was. Not only had the board knowingly skipped required steps, but they had done so based on a false claim that Lena hadn't responded. She had emails, certified receipts, photos, timestamps, proof of communication they claimed never happened. It wasn't just negligence anymore, it was fabrication. Enter the attorney. Lena then contacted a local HOA attorney not to sue, but to review the materials and advise. The lawyer's reaction was blunt. They've opened themselves up to a serious legal problem, denial of due process, misrepresentation of facts, and inconsistent enforcement. If this isn't corrected, it's not just unethical, it's actionable. The attorney drafted a formal demand letter asking the board to reimburse Lena's irrigation repair costs, remove any record of violation, refrain from further enforcement unless proper procedure is followed. He also warned of possible escalation to small claims court or a complaint to the state Department of Real Estate. The community awakens as Lena shared what she'd learned with neighbors. A pattern emerged. One resident had been fined for a paint color that was never on the banned list. Another had been denied permission for a solar panel, despite an active state law prohibiting such denial. A third had been billed for common area maintenance after the HOA skipped scheduled landscaping. The issue wasn't personal, it was systemic. The board, perhaps emboldened by years without challenge, had created an insular, self-justifying process where transparency was optional and dissent was punished. Taking it public, Lena prepared a presentation and brought it to the next HOA general meeting, which she attended along with over a dozen residents. What she showed stunned everyone. Copies of her emails, redacted board minutes, the mediation summary, state code excerpts showing the board had overstepped. Some residents applauded. Others demanded immediate answers. The board, visibly shaken, said they would review the concerns, but the air had shifted. No longer was Lena alone, and the board, once operating unchecked, now faced a community watching closely and asking the right questions. By this point in Lena's case, what began as a simple lawn irrigation issue had escalated into something far more troubling, a systemic pattern of abuse of power, hidden behind the closed doors of HOA procedure. This fifth segment reveals critical lessons about how transparency or the lack thereof is often the battlefield in homeowner disputes. 1. Records requests, the HOA's legal obligation. In most states, homeowners have the legal right to request access to meeting minutes, financial records, communications involving their property, vendor contracts, and invoices. These records must be provided within a statutory window, often 10 to 30 days, unless the board can cite a valid legal exemption. But here's the strategy some boards use. They stall or provide incomplete data. They claim confidentiality without justification. They redact or omit crucial portions, assuming the homeowner won't fight back. In Lena's case, the board redacted the very lines that could expose misconduct and got caught doing it. This is not just suspicious behavior. It's a potential violation of state law and a breach of fiduciary duty. To the non-responsive homeowner lie. One of the most dangerous tactics boards employ is false documentation claiming homeowners ignored notices or failed to respond. But Lena had email receipts, certified mail confirmations, timestamped communications. Her proof neutralized their narrative. This raises a deeper concern. If the board was willing to falsify this, what else have they misrepresented? This tactic is often used to justify skipping due process, which is required under most HOA bylaws and state laws. 3. The power of community meetings. When Lena brought her case public at an open board meeting, the impact was sonic. Why? HOAs often operate in silence. Most residents don't attend meetings. Board members rely on that silence to pass questionable actions without resistance. One well-prepared homeowner exposing misconduct in front of a room can destabilize years of unchecked authority. The key: Lena had documentation, code citations, and other homeowners backing her. This wasn't just confrontation, it was organized accountability. For what this means legally, an attorney reviewing this kind of case will look for: pattern of procedural violations, misuse of attorney threats, improper withholding of public records, retaliation for communication or advocacy. Any one of these may support legal remedies such as filing a complaint with the Department of Real Estate Small Claims Court for financial damages, civil litigation for retaliation or due process violations. 5. Lessons for every homeowner if you're facing a similar HOA conflict. Here's what you can do. Request records in writing. Always make your request formal, dated, and logged. Document everything. Every phone call, email, and mail delivery should be recorded with timestamps. Know your rights. Every state has its own HOA laws, some much stronger than others. Read your governing documents and your state statutes. Speak up publicly. Use board meetings to present your case not just to the board, but to the community watching. Consult an HOA attorney early. Even one consultation can help you determine how strong your position is legally. Red flags exposed in this segment: unjustified redactions, incomplete document production, misrepresentation of homeowner communication, board members making legal decisions without a vote, suppression of homeowner speech during meetings conclusion. This case study segment highlights how information is power and how some boards weaponize secrecy to maintain control, but it also proves that one prepared homeowner can shake an entire system, especially when backed by facts, law, and community support. The board wasn't done with Lena yet. After the confrontation at the meeting and the exposure of the redacted communications, there was a chilling pause. Then things took a darker turn. Lena thought the issue might de-escalate now that she had proven her case in front of the community. But instead, a quiet campaign of retaliation began. The small, petty penalties, it started subtly. A $25 fine appeared in her HOA portal account. The charge: unapproved, decorative item, porch area. It was a small, potted succulent on her front step. She had lived there for years without issue. Her neighbor had a matching one and wasn't fined. Then came a parking violation, even though she had parked in the same spot for 3 years without issue. It became clear the board was looking for anything they could use to punish her. The architectural review scam. Weeks later, she received a notice claiming she had installed a new hose, bibber type of outdoor faucet without prior board approval, except she hadn't. The bib was original to the home. She had just added a small lock to it after noticing others in the community experiencing water theft. The HOA demanded she submit an architectural review application retroactively along with a $150 fee. It felt like they were trying to trap me in paperwork, like they were building a file to make me the problem. Lena submitted documentation and photos proving it was not a modification. Still, the fine remained. The mysterious maintenance invoice. Next came a charge labeled common area damage, irrigation tap. for $640. The invoice was vague, no description, just the charge, billed directly to her. When Lena requested a copy of the vendor's report, the board refused to release it. She had already proven that her irrigation was connected to a shared system, but now it seemed they were blaming her for something without offering evidence. Connecting the dots by this point, the retaliation wasn't just suspected, it was calculated. The timeline was clear: public exposure of board behavior, retaliatory fines, and made-up violations, denial of access to proof, financial pressure applied through petty but persistent billing. Lena was no longer just facing a board acting in error. She was now the target of a coordinated campaign to wear her down. Isolated but not alone neighbors began reaching out quietly. One mentioned they had also been fined for a decoration, but the charge vanished after they asked questions. Another admitted they'd stopped attending board meetings because they feared retribution. Lena realized retaliation wasn't new. It was just rarely challenged, but she refused to back down. She took the fight upstream, armed with a detailed record of every action taken against her since the public meeting. Lena contacted the state HOA ombudsman, her local council member, a local HOA reform watchdog group. What started as one woman's defense against a broken sprinkler charge was now entering the realm of advocacy. They wanted me quiet. They thought if they hit me with enough fees, letters, and threats, I'd fold. But I kept every receipt, every letter, every voicemail. I was done being afraid. Lena's experience marks a critical inflection point in many real-life HOA conflicts: retaliation. When a homeowner stands up to a board, especially one that operates without proper oversight, it often triggers a calculated backlash. This is not just frustrating, it's potentially illegal. Let's unpack the key components of what just happened. 1. Pattern recognition. Retaliation versus enforcement. When enforcement becomes selective, targeted, and sudden, especially after a dispute, it's no longer management, it's retaliation. In this case, Lena was targeted for a porch decoration no one else was fined for. She was falsely accused of modifying property hose bib, with no architectural change. She received an unexplained $640 charge with no vendor proof. This is textbook board retaliation, and in many states, it's explicitly prohibited by HOA law or consumer protection statutes. 2. Red flags. Every homeowner should watch for retaliation. Usually reveals itself in these forms: petty violations following a dispute, fines for non-existent rule breaking or rules inconsistently applied, administrative stonewalling, refusal to provide evidence or documents, fee stacking to increase pressure, sudden interest in enforcement against one homeowner while ignoring others. When multiple red flags occur in sequence, document everything. It may prove intent if legal action is necessary. 3. Denying access to evidence. A legal misstep. HOAs are typically required to provide detailed ledgers for charges, vendor reports, and maintenance records, board, meeting minutes, and decisions affecting homeowners. Refusal to share this information violates transparency laws and can open the HOA up to legal scrutiny. Lena's demand for vendor records, denied without cause, is a clear procedural breach. 4. Weaponization of HOA rules. It's not the rule itself, but how it's used that defines abuse. A rule requiring review of outdoor fixtures makes sense, but using that rule against a pre-installed hose bib is manufactured enforcement. Charging retroactive architectural review fees for something that predates the homeowner, that's a malicious application, not governance. This is where power within an HOA structure is often abused, especially when boards face little or no accountability. 5. Protective measures. Homeowners should take. Lena made the right moves, and others can follow suit. Track every violation, letter, and charge with dates, screenshots, and physical copies. Request documentation via certified mail or email with read receipts. Involve neutral third parties: ombudsman, city officials, or legal clinics. Gather community testimonials, especially if neighbors are quietly targeted too. Escalate calmly but assertively. HOA boards often back down when challenged with documentation and external pressure. 6. The bigger picture. HOA abuse isn't just personal. Lena's retaliation story mirrors thousands of cases nationwide. From California to Florida, HOA retaliation has become a flashpoint in housing law reform debates. Some states, like Colorado and Nevada, have already moved toward creating homeowner protection offices to handle abuse. HOA retaliation has evolved from isolated incidents to a systemic governance problem, and awareness is the first line of defense. Retaliation is the HOA's silent weapon. It's rarely admitted, but often felt, and it can destroy trust in a community faster than any fine or fee. When power goes unchecked, homeowners like Lena remind us what resilience looks like. By this point, Lena had endured a series of events that transformed a simple lawn issue into a maze of accusations, fees, and attorney threats. But the most bewildering blow came in the form of a charge $640, abruptly added to her HOA ledger with no breakdown, no context, and certainly no explanation. When she opened the email from the HOA's property management company, she expected to see a routine update. Instead, she was blindsided by a balance statement. Her account now reflected this massive charge under a vague line item labeled architectural compliance fees. Lena immediately fired off an email asking the obvious. What is this for? Who did the work? Where's the invoice? She waited and waited. No reply. The charge that came out of nowhere, the $640 charge, was supposedly tied to unapproved modifications, including the hose by a small spigot on the side of her home that had existed since before she bought the property. She'd lived there over 6 years, never touched it, never changed it, never received a single violation for it. Now suddenly it was a problem, and a costly one. When she asked for evidence, the HOA offered a bizarre explanation that the hose bib had not been reviewed for architectural compliance, yet no notice had ever been issued, no request for removal, no formal review process had occurred. What's more, they refused to provide any documentation of how the $640 had been calculated. No receipts, no third-party invoices, nothing. Communications blackout for most of the dispute. Lena had attempted to handle things respectfully and constructively. She kept her emails factual. She offered proof of her actions. She even asked to speak directly with the board during their next open meeting. But now, the communication channels dried up entirely. The management company stopped responding. The board never replied. Weeks passed, still silence. It felt deliberate. A form of slow suffocation meant to frustrate her into giving up or paying without protest. The breakthrough. Discovering state HOA law. Lena decided it was time to go deeper. She began researching her state's HOA laws and discovered something that changed everything. HOAs are legally required to provide financial disclosures upon request. Charges exceeding a certain amount must be accompanied by vendor documentation. Homeowners have the right to challenge architectural review findings, especially if no prior violation was issued. She had rights, clear written rights, and her HOA was actively violating several of them. The call to an ombudsman. Lena reached out to her state's HOA ombudsman office, a public advocacy resource designed for situations just like this. She documented everything: the original violation, the mediation notice, the attorney letters, the ignored emails, the $640 fee. Within a week, she received a response. You may file an official grievance. The HOA is required to justify all monetary charges with documentation. Failure to do so may constitute financial misconduct. That single response validated everything she had suspected for months. Neighbors start talking. Around this same time, Lena began discreetly speaking with a few neighbors. What she discovered was eye-opening. One neighbor had been fined $250 for a discolored patio umbrella despite having a brand new one. Another had been charged for weed removal that they never requested and that no one could prove occurred. A third was in small claims court over a late fee he says he never received notice for. The pattern was clear. The HOA board had been engaging in unexplained and potentially predatory financial practices, possibly using violation notices as a revenue stream, putting the fire out or fueling it. At this point, Lena had a choice. She could pay the $640 out of frustration and close the book, or challenge the charge legally. Armed with her ombudsman's response and state law, she chose the latter. She filed a formal complaint, citing the lack of documentation, failure to respond, and misapplication of the HOA's own architectural guidelines. And that's when something unexpected happened. The HOA's attorney responded within 48 hours. Suddenly, they were willing to review the charge. They suggested the fee may have been applied in error, and that Lena need not take further legal steps. The silence had broken, but only because Lena had pushed back louder than they anticipated. The bigger realization this moment crystallized the reality for Lena. HOAs often act not because they're right, but because they believe you won't challenge them. Once challenged, especially with law on your side, the tone shifts, the power dynamic cracks, and fear changes sides. But the process had taken a toll. She was emotionally drained, financially stressed, and constantly on edge in her own home, the place that was supposed to be her sanctuary. As the next wave of retaliation loomed, Lena realized this battle was no longer just about lawn violations or hose bibs. It was about how easily power could be abused when homeowners stay silent. She wasn't going to stay silent anymore. What we see in this segment is one of the most underreported tactics used by problematic HOAs: financial ambiguity weaponized for control. Let's break this down. Unexplained charges as leverage when a homeowner receives a $640 charge with no prior notice, no supporting invoice, and no clear violation. What's really happening? This isn't just poor administration, it's a deliberate strategy. The board or management company may be using the appearance of authority to pressure homeowners into compliance without proof, avoid due process by skipping warning notices and hearings, intimidate through silence, hoping most residents will pay rather than fight. In many states, any fee charged by an HOA must be documented and justified, especially if it involves third-party vendors. Without this transparency, such charges may actually be illegal. The architectural violation, excuse claiming that a 6-year-old hose bib wasn't approved, is a textbook example of retroactive enforcement. Boards will sometimes reinterpret outdated or vague rules to impose sudden fines, often hoping homeowners are unaware of the statute of limitations on enforcement. A homeowner like Lena who asks questions and requests documentation disrupts this system. That's when the game changes. Legal leverage begins with documentation, her smartest move. Involving the state ombudsman, every HOA-regulated state has some form of homeowner protection office. By going external and citing actual law, Lena forced the HOA to either respond or risk exposure. Silence was no longer their shield. If your HOA begins issuing vague charges or refuses documentation, they're hoping you'll feel isolated, don't be likely protected under state land. It's your right to demand clarity and fairness. The letter came certified, its return address from a law firm Lena didn't recognize. When she opened it, her stomach dropped. You are hereby notified of a mandatory mediation session scheduled for next month. Regarding continued violations of HOA guidelines, there was no attached documentation. No reference to specific violations, no summary of findings, just a date, a time, and the unmistakable tone of legal escalation. Lena sat down with the envelope trembling in her hands. After months of unreturned emails, vague notices, and unexplained fines, the HOA had now skipped directly to legal mediation, a step typically reserved for serious, ongoing disputes. In Lena's case, she still wasn't even sure what she had allegedly done wrong. They want me in mediation without a case file. Most HOAs follow a standard conflict resolution chain. Notice of violation, opportunity to cure fines or warnings, internal hearing, mediation, or arbitration. Lena had seen step 1, but steps 2 through 4, those had been bypassed completely. This wasn't due process. It felt like a trap, one that could lock her into a legal agreement without fully knowing what she was defending against. She began documenting everything: timelines, emails, even the overgrowth logs from when her sprinkler system was broken. She cross-referenced dates, took photos, and began preparing not just for mediation, but for a fight. The ombudsman responds. Just days after the mediation letter arrived, Lena heard back from the state HOA ombudsman's office. We have received your inquiry and are currently reviewing the board's behavior in accordance with NRS Chapter 116. For the first time, she had confirmation. This wasn't just an interpersonal conflict. This was potentially a violation of state law. The letter also noted that if the HOA had failed to notify her of hearings or decisions, as her records clearly showed, they were in breach of their own CC and Rs and potentially acting in bad faith. She now had more than just her voice. She had leverage. The missing hearing, Lena's request for hearing transcripts, records of board meetings, and architectural approval logs went unanswered for 2 more weeks. Then, a short email arrived from the property manager. We are unable to provide the requested records at this time. That was it. No apology, no reason, just denial. Her attorney, who she'd been consulting since the mediation letter arrived, advised her to issue a formal records request under state HOA transparency laws. When she did, the HOA had 5 business days to comply or risk a complaint filed with the Division of Real Estate. The timer had started ticking, preparing for mediation on her terms. Lena was no longer approaching mediation as a passive participant. She was building a countercase, a timeline of events from the irrigation system repair. Emails and photos documenting her attempts to maintain the lawn, screenshots of unanswered board correspondence, the denied records requests and ombudsman's acknowledgement letter, affidavits from 2 neighbors who confirmed they were also denied basic architectural approvals. She also uncovered something stunning. The property management company handling their HOA had been involved in multiple lawsuits in other communities for aggressive enforcement and poor communication. Court records showed similar cases: misused fines, withheld documents, and phantom violations. She printed every single one. This isn't just about me anymore. As Lena prepped for mediation, she realized her fight wasn't just personal, it was emblematic of something much larger. She began contacting other homeowners in her subdivision, quietly comparing notes. That's when the pattern became clear. Several residents had been charged vague landscape violation fees. At least 3 had received non-compliance letters with no evidence. One elderly couple had paid over $1,200 in fines for a decorative fence that had been approved years ago, only to later learn the records had been lost. It wasn't disorganization, it was systemic, and Lena was about to expose it. Day of the mediation. When Lena walked into the mediation room, she wasn't alone. Her attorney was by her side. A community advocate from a local housing rights nonprofit sat quietly behind her. The HOA sent their board president and an attorney. The mediator, retired judge, welcomed both parties. Then Lena spoke first. Before we begin, I'd like to provide some materials that might clarify my position. She passed out binders to the mediator and opposing counsel, labeled indexed and professionally presented. Photos, emails, dates, law citations, copies of the state HOA handbook, the ombudsman's letter, affidavits. The HOA attorney's eyes narrowed as he flipped through. The mediator, halfway through Lena's opening presentation, paused and looked at the board president. Why wasn't this homeowner given proper notice of these alleged violations? No answer. And why were these fines issued without documentation? Silence again. The session continued for another hour, but it was clear the HOA had no substantial case. The attorney suggested resolving this privately. Lena declined. I'm happy to proceed, but only with full public records disclosure. This is not about one host bib, it's about governance. The mediator nodded. This mediation is concluded without resolution. The homeowner is free to escalate, and escalate she would. What we VA just witnessed in Lena S. case is a textbook example of procedural abuse, an HOA leveraging the formality of mediation not to resolve, but to intimidate. Let's break this down. Most HOAs are required either by law or their own bylaws to follow a clear chain of enforcement. Violation noticed gives reasonable cure, period, gives hearing, gives fines, gives, and only then, if unresolved, mediation or arbitration. In Lena's case, nearly every step was skipped. That's more than a red flag. It's a breach of fiduciary duty, and possibly even a violation of state law, especially in jurisdictions with homeowner protection statutes like Nevada's NRS 116. Mediation is meant to be collaborative. Instead, it was wielded as a weapon, forcing a homeowner into a legal environment under threat, with no prior communication, no disclosed documentation, and no established grounds for violation. And this wasn't just a communication failure. Lena's HOA appears to have knowingly withheld records, dodged transparency obligations, and attempted to sidestep procedural fairness, possibly to avoid scrutiny of a flawed or retaliatory enforcement pattern. Her counter-strategy was powerful. She documented everything. She contacted the state ombudsman, she triggered her legal right to records, and she built a clear timeline of accountability. Takeaway for homeowners: if your HOA suddenly escalates to mediation without walking through the proper steps, don't walk in unarmed. Demand records, involve oversight bodies, and remember, a prepared homeowner can dismantle a flawed HOA case with clarity and courage. Because once mediation is weaponized, the only shield you have is documentation and due process. Lena's breaking point wasn't the fine, it wasn't even the mediation summons. It was the silence, the emails that went unanswered, the board meetings she was excluded from, and the growing realization that this wasn't just about her lawn. So, she escalated. She filed a formal complaint with the state's Department of Real Estate, which oversees HOA conduct in her jurisdiction. Her case was assigned to an investigator within 2 weeks, and she submitted a complete file of documents, violation letters, mediation summons, repair receipts, and dated communications with the board president. What she didn't know at the time was that her case would trigger a broader review of the HOA's history of enforcement actions. Meanwhile, Lena reached out to a local consumer watchdog segment called Neighborhood Rights. She wasn't sure they'd respond, but within days, a field reporter contacted her. They were intrigued not just by the pettiness of the HOA's actions, but by the pattern of intimidation toward multiple homeowners in the development. Lena wasn't alone. In a televised segment aired 2 weeks later, Lena stood in her front yard, holding the certified letter that threatened legal action over a now-repaired irrigation system. Behind her, the lawn was green, well-trimmed, and indistinguishable from her neighbors. Viewers were shocked. Hundreds of emails flooded the station. Other homeowners from the same HOA wrote in anonymously, describing similar harassment, unexplained fines, and sudden mediation orders for minor or disputed violations. The coverage struck a nerve. That's when Lena's attorney, pro bono from a legal nonprofit, filed a motion to compel full financial transparency from the HOA. They suspected misuse of funds legal retainers spent excessively to target homeowners instead of resolving structural issues in the neighborhood. The court granted the motion. What they uncovered was damning. Over $80,000 had been spent in legal fees over 2 years, mostly tied to disputes involving small, repairable code violations. At the same time, the HOA's reserve fund was dangerously low, and several urgent infrastructure repairs like community pathway lighting and stormwater drainage had been deferred indefinitely. The story was now bigger than Lena. It was about an HOA with misaligned priorities, retaliatory enforcement, and possible financial mismanagement. The pressure on the board intensified. Homeowners began organizing informally. A secret Facebook group became the hub for sharing documents, recording board meeting audio, and posting updates about the investigation. Some homeowners had feared speaking out, but seeing Lena take a stand, and the news segment go viral, they felt emboldened. By month's end, 3 board members voluntarily resigned. A recall petition circulated quickly and secured enough signatures to trigger a special election. Lena didn't run for office herself, but she endorsed 2 neighbors who had long histories of advocating for transparency and repair of the neglected common areas. They won in a landslide. With new leadership came immediate reforms. Legal spending was frozen pending audit. Violation policy was revised to include transparent appeal timelines and homeowner education. The irrigation system was re-evaluated, with a professional landscaper hired to assess shared line configurations and eliminate ambiguity. Most importantly, Lena's complaint to the state led to regulatory reform proposals, requiring mediation to follow proper enforcement protocol not preceded. Her situation was cited in a hearing as an example of abuse that could have been avoided with better HOA checks and balances. The media segment, it ended up being nominated for a regional journalism award. For the first time in months, Lena felt peace. The violation that sparked this nightmare now lived only in her scanned documents folder, but its consequences had transformed her community. Her neighbors started gathering on Sunday mornings for coffee in the common area. Children rode bikes freely without parents fearing sudden letters or fines, and HOA board meetings became a place for problem-solving, not punishment. The scars were still there, emotional and financial. Lena had lost time, energy, and sleep, but in the process she'd exposed a structural failure and helped rebuild something better. Sometimes, the most ordinary acts like fixing your lawn can reveal extraordinary dysfunction, and sometimes all it takes is one homeowner saying enough to change everything. Lena's move to file a formal complaint with the Department of Real Estate shows the importance of using regulatory-backed channels. In many states, departments or commissions provide oversight of HOA conduct, but most homeowners either know they exist or assume they're ineffective. Lena's documented case gave them the leverage to investigate not just her complaint, but patterns of overreach. Public exposure works. HOAs often count on intimidation and silence. But when Lena went public, the tide shifted. Consumer advocacy media like neighborhood watchdogs or local investigative journalists can hold boards publicly accountable in ways courts and regulators can teach. It's not just about embarrassment. It's about forcing transparency by making secrecy impossible. Financial transparency equals Achilles' heel. The court-ordered audit revealing $80,000 in unnecessary legal fees exposed a misalignment of fiduciary priorities. Boards are legally obligated to act in the best interests of the entire association. Excessive legal action against homeowners for minor violations, especially when key repairs are being neglected, is a red flag for mismanagement, and possibly even embezzlement. Strategic takeaways: know your state's HOA regulatory body and how to file complaints. Document everything, especially correspondence and board decisions. If necessary, Go public media attention amplifies pressure. Push for financial audits and insist on transparency. And finally, remember, you, Dan T., have to run for office to reform your community. You just have to spark the movement. By the time Lena received her 5th legal threat letter, she'd gone from feeling overwhelmed to fully engaged in fighting back. But something had shifted, not just in Lena, but in the community around her. Her once quiet cul-de-sac was now buzzing with conversations that had been suppressed for years. Other homeowners began coming forward with similar horror stories, threats over mailbox designs, citations for invisible weeds, fines for leaving garbage cans out 30 minutes too long. One neighbor, Dave, revealed he had paid $1,200 in legal fees over a crack in his driveway. The HOA itself had caused during a utility dig. Lena began hosting informal gatherings in her garage at first just for support, but soon they became strategy sessions. A local attorney volunteered time. A neighbor with a background in public records started combing through HOA filings. What they uncovered shocked everyone: the paper trail of abuse. The HOA's law firm had billed the association $94,000 in the past 2 years, much of it attributed to actions against homeowners for minor violations. Lena's case alone had generated over $7,800 in fees, despite being resolved in mediation with no fine once the irrigation repairs were confirmed. Even more damning, the president of the HOA board had personal ties to the law firm and had never disclosed the conflict of interest. The more they dug, the more they found unapproved contracts, questionable reimbursements, and secret board meetings that violated open meeting requirements. This wasn't a case of negligence, it was calculated control. The open forum that changed everything. Lena and her neighbors demanded a special meeting under the HOAs bylaws. They met quorum for the first time in years. Word spread fast. Local media showed up, so did a state housing official, who'd been quietly tracking similar complaints across the region. When the meeting started, the HOA board president tried to adjourn immediately, claiming it wasn't properly noticed. But the homeowners had come prepared. They cited the governing documents, the relevant statutes, and distributed copies of correspondence showing intentional delays and obstruction by the board. Then Lena stood up. "I didn't ask to lead this fight. I just wanted to fix my lawn. But in trying to do that, I learned how broken this system really is and how easily it can be abused when no one else watching." Today we're watching. The room erupted in applause. A vote that made history by the end of that night. A vote of no confidence removed 3 board members, including the president. A temporary ethics committee was formed, and forensic audits were approved by majority vote. Over the next 3 months, the new interim board enacted sweeping reforms: transparent bidding on all vendor contracts, mandatory legal review of board actions, monthly financial disclosures available online, and the removal of the HOA's long-standing legal counsel. Homeowners felt hopeful again. Kids returned to play in common areas once off limits due to arbitrary rules. Flower beds that once had to conform to HOA-approved mulch color now bloomed with diversity. It was subtle but meaningful. From defendant to advocate, Lena could have walked away satisfied, but she didn't. Instead, she started a website where homeowners could anonymously share their experiences and connect with pro bono legal resources. She spoke on a housing reform podcast. She even testified before the state assembly as a case example of why HOA laws needed teeth. Her story helped fuel the passage of Senate Bill 422, requiring independent auditing of HOAs over 50 homes, disclosure of board member affiliations, easier legal recourse for homeowners. The law passed by a margin of 82 to 18. The final scene a year later. Lena sat at her newly landscaped front yard, one that finally met every HOA guideline. Not because she feared a violation, but because the community helped her design it. A small sign near the walkway read, "This lawn once sparked a war. Now, it grows in peace." She smiled as kids biked by and neighbors waved. The HOA wasn't perfect, but now it served the people, not controlled them. And that, she realized, was what she had fought for all along. By the conclusion of Lena's story, we not just looking at a resolved dispute, we're looking at a case study in structural reform that should be required viewing for any HOA board member, property manager, or homeowner. This wasn't just about irrigation. It became a battle for transparency, accountability, and basic neighborly fairness. Let's break down the key takeaways. Community power works when it's organized. Lena didn't win because she had more money or legal leverage. She won because she mobilized her neighbors, followed due process, and demanded her HOA operate by the rules it was sworn to uphold. When the community organized with intention, even the most entrenched board couldn't withstand scrutiny. Sunshine is the best disinfectant. One of the most transformative moments came when Lena forced a public meeting with proper notice and quorum. HOA abuse often thrives in the shadows, in quiet legal letters, hidden audits, and small print. But public exposure shifted the narrative from a difficult homeowner to a community confronting a broken system. Transparency changes everything. Real reform requires legal tools and legislative change. Lena's impact didn't stop at her neighborhood. Her advocacy led to statewide legislative reforms, proving that even local disputes can shape policy when well documented and publicly supported. Too often, HOA abuses are dismissed as isolated, but when framed as patterns, they open doors to systemic change. Final expert advice: know your bylaws, but don't be intimidated by them. Rally neighbors, you're rarely alone in your frustration. Escalate responsibly. Documentation, state complaints, public forums. Use every platform available: media, podcasts, hearings, to tell the truth. And most importantly, never mistake silence for compliance. Lena didn't just fight the HOA, she transformed it. What began with a broken irrigation pipe and an unjust violation notice became a turning point for an entire community, and perhaps even for HOA governance nationwide. Lena's battle was never just about lawn maintenance. It was about being heard. It was about fighting back against weaponized bureaucracy. It was about refusing to be intimidated into silence by a system that counts on homeowners giving up. She didn't just resist. She redefined what it means to be a homeowner in the face of unchecked authority. By the end of this saga, the HOA wasn't just restructured, it was reborn. Transparent elections, rotating leadership, a publicly accessible budget, and a community that finally started acting like a community. Neighbors who once barely spoke now plan events together, host shared lawn equipment days, and hold biannual open forums where every homeowner can voice concerns without fear of retaliation. And Lena, she didn't stop when the letters from the attorney stopped. She went further. She wrote articles, spoke at housing forums, helped pass a local ordinance requiring all HOAs in her city to post violations publicly before legal action can be taken, ensuring no one else faces what she did in the dark. But the most powerful change wasn't legal, it was cultural. People learned to ask questions, to demand answers, to treat HOA board seats as positions of service, not power, and in neighborhoods across the country, others began to take notice. This story isn't about a hero defeating a villain, it's about ordinary people refusing to be ignored. It's about one woman's persistence turning fear into action, and it's about what can happen when enough people say, that's enough. So, if you're watching this and dealing with your own HOA nightmare, know this: you're not alone, you're not crazy, and you have more power than they want you to believe. Don't let silence be their weapon. Let your voice be your defense, let your neighbors be your allies, and let this video be your reminder that justice isn't always delivered in court. Sometimes, it starts in your front yard. Drop your own HOA horror story in the comments. Share this video with someone battling boardroom bullies, and subscribe to Karen's Stories, where everyday people fight back against corrupt systems, and win. This was She Thought I Was Just a Homeowner, I'm a Federal Judge. The true story of HOA corruption, retaliation, and ultimate justice. Because no matter what your HOA tells you, you still have rights. And more importantly, you have a community. Thanks for watching. See you in the next fight for justice.